As a responsible business owner, you've purchased a workers' compensation policy. You understand this insurance will protect you and your business from suits brought by your employees for injuries in the workplace and pay those injured workers medical costs and part of their lost wages as a result of work-related injury or illness. But you may still have some lingering questions. Are there employees that don't have to be covered by workers' compensation? If so, can that negatively impact the business even if you're in compliance with the law? When is an injury or illness work-related? And what happens if you have employees who travel to other states to perform their duties and are injured in those other states? If you have questions or concerns in any of these areas, you're in the right place because that's exactly what we're going to be talking about. Let's start with, who is an employee? The question, is a worker an employee, seems like a simple one to answer on its surface. Various state workers' compensation laws broadly define an employee as a person who works for another in return for financial or other compensation. But employer-employee relationships can exist outside of this context. In fact, employer status can be created in a number of ways. There can be direct, statutory, and special employer status. You need to understand them so that you can manage your workers' compensation exposures accordingly. Direct employer status is most common. This relationship is created through a contract of hire, either verbal or written, and the employee's acceptance of the position. Direct employers have certain rights. The right to hire and fire the employee, of course as allowed by state law. The right to exercise control over the employee's work hours, work locations, work methods. In addition, a direct employer pays wages on a regularly scheduled basis in an agreed-upon form, salary, commission, piecework, or some other means, and the necessary taxes are withheld from the worker's paycheck. Direct employees are eligible to receive benefits that the employer provides to other workers, including health benefits, 401k, profit-sharing plans, retirement programs. Generally, they're eligible to receive state or federally mandated unemployment benefits if they lose their job, and certainly they qualify as an employee for workers' compensation. But what about independent contractors? Sometimes there are financial benefits to the employer to use independent contractors rather than direct employees, and not just from the standpoint of the workers' compensation policy and premium. So what establishes a worker as an independent contractor versus an employee? Tax law and workers' compensation law don't sync up in determining employee versus independent contractor status. When it comes to workers' compensation law, payment reported using a 1099 is not, in and of itself, sufficient to establish the worker as an independent contractor. A written contract stating that the worker is an independent contractor will not necessarily guarantee this status either. How then can you determine status? The conditions under which a person is working governs whether that person is an employee or an independent contractor. A very simple way to look at this really comes down to control. Who controls the work and the work process? Who controls the means of performing the services or work? What about the hours they work and the method of operation? A true independent contractor is self-employed. It's obviously better to make this determination and distinction between a direct employee and a true independent contractor before a serious injury is sustained. What about subcontractors, and how are they different from independent contractors? In 44 states, the upper tier contractor is responsible for providing or arranging for workers' compensation benefits to an injured worker of an uninsured subcontractor's employees. So even though this upper tier contractor is not the direct employer, by law in these states, they have become the statutory employer, a relationship created because of state law. So what is a subcontractor, and can injuries to their employees come back to you? Three parties are involved in any subcontractor relationship: the principal, which could be the business owner or the property owner, who contracts with a true independent contractor, and remember that gets back to the issue of control of the work and the work process. That independent contractor then can create a subcontractor relationship by contracting out some or all of that work to another entity. These kinds of relationships don't just exist in the construction arena. If you, as a business owner, hire someone to install computer equipment or design a website, and that independent contractor then subcontracts the actual work to a technology business, a subcontractor relationship between the person you hired and the technology firm has been created. If the employees of the technology business, the subcontractor, are uninsured, the independent contractor in 44 states will be required to provide a response if they're injured. If the independent contractor the business owner hired is uninsured for workers' compensation, the injury to the subcontractor's employees may come back to the business owner. Having contracts in place that are clear regarding who is responsible for providing the necessary insurance is important. There are other business circumstances that can create an employer-employee relationship. We refer to the employer in some of those as a special employer. If you've ever hired a temporary worker from a placement service, or if you've leased employees long-term, you may have fallen into the category of special employer. If a temporary or leased employee is injured on the job, determining who the employer is and who should have provided workers' compensation coverage gets back to that issue of control. Who was controlling the work and the environment when the injury occurred? Again, a well-written contract that outlines who will be providing workers' compensation coverage is a good risk management tool in these employer-employee relationships. We've talked briefly about three types of employer-employee relationships that have an impact on your workers' compensation program. A business owner may have any or all of these relationships throughout a single policy term. Discuss how to tailor the Hartford's workers' compensation offerings to your specific business exposure with your Hartford insurance professional. We've talked about what employer-employee relationships might require a business owner to treat a worker as an employee and provide them with workers' compensation benefits. But there are situations where a worker, even a direct employee, may be exempt from being required to be covered. It's important to recognize that the workers' compensation laws in every state are different and to determine how those laws apply in your state and to your business circumstances. To do that, you should have further discussions with your insurance advisor. Let's start with volunteer workers. Workers' compensation was created to respond to injuries to employees suffered in the course of employment. Are volunteers employees? By definition, a volunteer is a person who performs or offers to perform a service without pay or other compensation. Except under certain circumstances as defined by the various state workers' compensation laws, volunteers are not considered employees and if injured on the job are not entitled to workers' compensation benefits. Volunteers may be injured while performing a service for your business, and without access to work comp benefits, their recourse to recover medical costs or lost wages is through the legal system, which could cost you both time and money. Voluntary compensation coverage can be added to your workers' compensation policy to provide coverage for volunteers and other workers that are not required to be covered by workers' compensation. We're talking about who is exempt from workers' compensation laws, which workers are not required to be covered. Currently, 37 states and the District of Columbia require every employer with one or more employees to provide workers' compensation coverage. The remaining 13 states allow an employer to forego workers' compensation coverage until they reach a certain threshold number of employees. That number varies by state, and in a few of those threshold states, the number is reduced if an employer falls in a contractor category. Knowing those facts in the states where your business has operations and determining how many employees you have in each state is important to be sure you're in compliance with the law. Employers are not required to be covered by work comp. Employees are. Who is an employer is determined by the legal structure of the business and the state work comp laws, which vary significantly from state to state. Sole proprietors, or individuals, in most states are treated as the employer and are exempt from the work comp law. When that's the case, they don't count towards the total number of employees the business has. However, they can choose to be covered by the work comp law and receive benefits for their work-related injuries. Partners are also generally treated as the employer and are exempt from the work comp law, but can choose to be covered. There are a few states where partners are considered to be employees, but in those cases they can choose to exempt themselves from the law with the use of a rejection notice. Saving premium dollars is the motivation when a business excludes sole proprietors and partners from workers' comp coverage. But since many health insurance policies don't cover work-related injuries, consideration should be given when making this business decision. Corporations are legal entities and are considered the employer. Corporate officers are employees of this legal entity and count towards the total number of employees. In most states, certain corporate officers can exclude themselves from workers' compensation protection by completion of a rejection form. Again, the motivation to exclude employees is related to work comp premium reduction, but consideration needs to be given to how these employees' work-related injuries will be covered. The states are split in their handling of limited liability companies and whether or not the members and managers are the employers or the employee. If your business structure is an LLC, further discussion with your insurance professional is recommended. What other workers are exempt from the requirements of the workers' compensation laws? Nearly every state work comp law has an exclusion for casual labor, which is defined as work that's not in the normal course of the employer's trade, business, occupation, or profession. Perhaps a landscaper hired to maintain the grounds around a business location, or a painter hired to paint the exterior of the building. The difficulty is that the various work comp laws are unclear about what casual labor is. Some define it with subjective words like brief, occasional, or sporadic. Some apply a dollar value amount that can be paid for the work. Sometimes what you thought was casual labor turns up at audit to be an employer-employee relationship. It's important to evaluate each potential employer-employee relationship a business enters into. We've discussed several classes of workers that are not typically required to be covered by workers' compensation: volunteers, sole proprietors, partners, employees below the threshold number in 13 states, and casual labor. Any of these workers can still be injured while performing work for you, and if not covered by workers' compensation, the only legal recourse they have, if they feel their injury was negligently caused, is through the legal system. It's important to weigh the benefits and the costs associated with providing these exempt employees with workers' compensation coverage. In the first two segments, talking about who is an employee and who is exempt, We emphasize that the workers' compensation laws differ widely from state to state regarding things like the definition of employee, the threshold from compulsory coverage, the contractor-subcontractor relationship, and I should also add regarding the benefits schedules, what's payable under the work comp law. But all states agree that in order for an accident or an illness to be covered, it must arise out of and in the course and scope of employment. This seems fairly simple, but let's look at each of those elements a little bit more closely. The first criteria for an injury or illness to be compensable is that it has to be related to the employer's business. It has to arise from on-the-job activities. There needs to be a connection between the employer's business and the injury. One gauge of this is to consider if the employer benefited in some way from the activity the employee was engaged in at the time of injury. The second requirement is that the injury or illness must happen in the course of performing operations for the employer and at either the business location of the employer or a location mandated or reasonably expected by the employer. This expands an employer's responsibility for employee injury or illness beyond job site injuries to circumstances which might not normally be considered by the employer to be on the job. We'll look at some examples. The term scope of employment more specifically defines the first two items, arising out of and in the course of. It's defined as activities which further the business of the employer and where the employer is or could be exercising some control. This is looking at the employer's direction and control over the employee and the employee's motivation to perform the activity. Was it to further the interest of the employer's business? Injuries can arise out of the employment and during the course of employment, but be outside the scope of employment. Consider as an example a business employee entertaining clients at a restaurant who gets into a fight with patrons at another table and is injured. Would the actions of the employee be considered in the scope of employment? Were the employer's goals furthered by that fight? Did the employer control the behavior? Establishing an injury as work-related is much simpler when employees work from a fixed place of employment on a fixed schedule and are injured while in the midst of their assigned duties. A manufacturing employee injured while using a machine during his shift will likely be considered a compensable injury. An employee in a grocery store injured when they fall from a ladder while stocking shelves during their shift, again, very likely a compensable injury. But in today's business environment, there are lots of non-traditional work circumstances that create questions regarding whether or not an injury is compensable, such as employees who travel, employees who work from home, or employees who attend employer-sponsored social activities. So employees who travel, and will restrict this travel within the state of hire. In most states, injuries incurred in travel to and from work are not considered compensable, with some exceptions. But employees required to travel to perform the job at another location, such as salespeople, auditors, employees attending out-of-town meetings or training, or those asked to work at a new job site, are considered to be in the course and scope of employment during that travel. Some other employees have the same exposure. Delivery drivers, specialty trade contractors like an electrician or a plumber, office employees asked to pick up office supplies on their way to or from work, or to pick up and drop off the mail or make a bank deposit. What happens if the employee deviates from the direct travel path and stops for personal business along the way and is injured? Is that injury work-related? Or the salesperson who stays in a motel overnight and is injured in the motel? Is that work-related? There is no specific answer. Some states have well-defined laws that specify when a traveling employee is covered by the work comp law, others do not. But even where there is legislation, the courts can interpret the facts of each case differently. Employers who have employees that travel should have very clear policies in place regarding activities that are expected and financially reimbursed by the employer. Today, more and more employees are working from home. Financially, this might benefit the business owner, but the same standard of care for that employee is required as if they were working in the business location. Employees who work from home have a couple of unique work comp exposures to be considered. Potentially additional on-the-road exposure if perhaps they have a post office box or other mail arrangement rather than utilizing their home for safety reasons. This will require the employee to check that box periodically, and the difficulty in providing a safe and healthy work environment. At the job site, employers can assure that employee workspace is ergonomically designed. That same precaution needs to be taken with the home-based employees. Repetitive motion injuries, back injuries from incorrect desk setup, and posture and eye strain are just as likely among telecommuting employees as they are among office-based staff. Injuries that occur when the employee is at a company-sponsored picnic, holiday party, or engaged in a company-sponsored athletic event as part of a team. States differ in their statutory approach, and courts differ in their interpretation and application of the laws. But as general statements, the things considered are, where did the injury occur? Was it on the employer's or employer-owned premises? When did it occur? Was it during working hours, perhaps during lunch hour, or a recreational period that occurs as a regular course of employment and control? Did the employer require participation in the activity, or was it voluntary? Did the employer derive direct benefits from the activity, which could be interpreted as broadly as having the benefit of advertisement of the business on the shirts the team wears? Business owners should recognize that company-sponsored social activities can create a muted line between an injury that's work-related and one that is not. In order for an employee injury or illness to be covered under the workers' compensation law, it must be work-related. While we discussed what that means and that some states have clearly outlined what is included, traveling employees, for example, the courts can interpret that language differently depending on the details of the claim. How can a business owner protect themselves and their employees? It starts with recognizing your unique business exposures and discussing them with your insurance professional to develop appropriate safety or training programs, business practices, or insurance policy coverages for your business needs. We've talked about who is an employee, which workers are potentially exempt from the workers' compensation law, some of the things that are analyzed to determine if an injury or accident is considered payable. For each of these, we emphasize that the workers' compensation law in every state is different, and court decisions in interpreting the state work comp laws vary as well. As we discuss what happens when an employee is injured out of state, the differences between the state work comp laws become even more apparent and important. We need to understand the three parts of the workers' compensation policy for this discussion. Part 1 is designed to respond to work-related injury of an employee. Pretty straightforward. There's no limits on coverage. It will pay the statutory obligation, whatever the employer is legally obligated to pay as a result of the injury. This includes benefits for medical care, rehab, disability, and, should it occur, death. The premium for a business owner's workers' compensation policy is driven by the exposures in these areas, which states are involved, how many employees are there in these states, and what are the employee's duties. Part 2 of the work comp policy is employer's liability. It responds when an employer is sued by an employee or their immediate family for a work-related injury that isn't subject to state statutory benefits. Specific monetary limits are set. Loss of care or services from an injured spouse is an example. Part 3 of the work comp policy provides coverage for injuries or accidents to employees that occur outside of the states where there is known exposure and that are listed in Part 1. Since there's no known exposures for Part 3, there is initially no premium charge made. But if a business expands to other states after the policy is purchased, the business owner should notify the carrier so the proper coverage can be provided. Our focus is on Part 1, the statutory coverages that are required by state law, and Part 3, other states' insurance. As a sole proprietor or partnership whose business operates out of one or several locations all in the same state, with employees assigned to these specific locations only, deciding which states are listed as Part 1 states is relatively easy. It would be the state where the business operations are located. For Part 3, other states' insurance, even though it's unlikely that these employees will be asked to travel to another state during the course and scope of their employment, having broad other states' wording on the work comp policy will offer protection to them and to you if they do. This is an example of wording you would like to see on your policy. It's offering protection to the employees in the primary state of Florida and in all other states outside of the primary state and the monopolistic states, Ohio, North Dakota, Washington, and Wyoming. If we change this just a little bit and say that your business is a corporation rather than a sole proprietor or a partnership, the same thought process is followed unless the business was incorporated outside the state where the primary operations are carried out. Sometimes this is done for tax purposes. Now we have an additional state, the state of incorporation, that we should consider listing in Part 1 of the policy. When an employee is injured, some state work comp laws look at where the contract of hire was made, regardless of where the employee was working when they were injured. It's possible that the laws and the benefits of the state of incorporation might apply. Again, we see that broad other states wording, giving coverage to employees if they travel to states other than Florida or Illinois. What benefits is an employee entitled to if they're injured while outside of the state where they were hired or normally work? Do the benefits of the state where they were hired and normally work follow them? Or do the benefits of the state where the injury occurred apply? And again, it depends on the work comp law of each of the states involved. Specifically, it depends on what the work comp law of each state has to say regarding extraterritorial provisions and reciprocity. These are pretty impressive legal terms, but their meaning is fairly simple. Most state work comp laws are extraterritorial, which means the benefits of the employee's primary state follow them if they travel outside of the state temporarily. Different states interpret temporarily differently, and once an employee has been working in another state beyond a certain time frame, the new state's laws may apply. Extraterritorial provisions also run up against the way the other state law addresses reciprocity. Reciprocity means the state honors the extraterritorial provisions of another state as long as the other state honors theirs, and not all states do. Some states don't care what another state law provides, but say instead the employees working in their jurisdiction will be subject to the laws of the state where the employee is working at the time of injury. This allows injured employees benefits options. It can be overwhelming to consider all the potential possibilities and combinations, but the bottom line is, as an employer, you want to be in compliance with the law because of the legal and financial ramifications if you aren't, but you also want to protect your most valuable resource, your employees, in the event of work-related injury or illness. To be sure that your workers' compensation policy is correctly structured, have a detailed conversation with your insurance professional and explore questions like we have listed here. Are employees that travel outside of the state covered? Am I covered in all states for employers' liability, even the monopolistic states? Understand that where workers' compensation exposures exist, not just to out-of-state injuries, there also exist coverage solutions. In the case of having employees temporarily working in one of the monopolistic states, which are Ohio, North Dakota, Washington, and Wyoming, your insurance agent will not be able to obtain the statutory coverages for you, but will be able to provide you with information on how and when you need to provide that coverage for your employees working there or for those that you might hire in those states. You want to be sure that you have employer's liability coverage in those states. Employer's liability is that just-in-case insurance, just in case you're sued for a work-related injury to an employee or their close family member for something that falls outside the bounds of the workers' compensation laws. And thinking even bigger than just out of the state, what if you have employees who have business-related travel outside the country? Again, discuss this with your insurance professional to be sure that you and your employees are fully protected. We hope you found this information valuable and informative, and that you take the time to have a conversation with your insurance advisor about this necessary and important coverage. Thank you for listening.